In this video, we will discuss the relationship between municipal law and international law. Municipal law or state law is defined as the law that regulates the domestic aspects of government and deals with issues between individuals and the administrative apparatus. Whereas international law is defined as a law that primarily regulates the relations among the states and the relations of members of the international community. There are 5 theories that regulate the relation of municipal law and international law: Monism, Dualism, Specific Adoption Theory, Transformation Theory, and Delegation Theory. Let's discuss the theories of relation of municipal law and international law one by one. Monism. The exponents of this theory are Wright, Kelson, and Duguid. This theory states that international law and state law are intimately connected to each other, and international law and state law are 2 branches of unified knowledge. Man is the root of all laws. International law is law in the true sense of the term, and keeping in view this thought, monism seems to be reasonable and correct. For example, the Soviet system was generally based on dualism, but there are elements of monism there. According to the Soviet view, both state law and international law express the prevailing will of the people. Dualism. The exponents of this theory are Triepel and Anzilloti. This theory states that international law and state law are 2 distinct laws that remain in non-hierarchical dependence on each other. Dualism is based on the complete sovereignty of states. Let's have a look on Triepel's view. Regarding the subject of international law, Triepel says that individual is the subject of state law, whereas the state is the subject of international law. Regarding the origin, he opines that the origin of state law is the will of the state, while the origin of international law is the common will of the states. The criticism on his theory is that international law is not only binding upon states, but also on individuals and other non-state entities. The concept of state will as the source of state law is incorrect. State will is nothing but the will of the people who compose it. It is incorrect to say that the origin of international law is the common will of the states. In fact, there are certain fundamental principles of international law that are binding upon the state, even against their will. Now we will look at Anzilloti's view. He says that there is a difference between the fundamental principles of state law and international law. The fundamental principle of state law is that laws enacted by appropriate legislative authorities are to be obeyed. B. The fundamental principle of international law is pacta sunt servanda. He also maintains that the legal systems of state law and international law are different from each other. The criticism on his theory is that it fails to explain the binding force of customary rules of international law in regard to which the states have not given their consent. Specific Adoption Theory. International law can be applied in the field of municipal law only when municipal law either permits it or adopts it specifically. The criticism on this theory is that there are many general principles of international law that are applied in the field of municipal law without specific adoption. Next is transformation theory. For the application of international law in the field of municipal law, the rules of international law have to undergo transformation. The criticism on this theory is that it is not necessary for all treaties to undergo the transformation process for their application in the field of municipal law. There are several lawmaking treaties that become applicable to the states even without a transformation process. The last theory is the delegation theory. It says that constitutional rules of international law permit each state to determine how international treaties will become applicable in the field of state law. A question arises that in case of a conflict, which theory shall prevail? It is called question of primacy in international law. The answer to this question is that a mixture of international law supremacy and coordination of legal systems be practiced when it comes to conflict between the prevalence of theories.